I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my model of clarity co-host, Brett.
I try to do what I can, Alice. I try to keep it simple and straightforward. Don't want to confuse anybody.
Well, thanks for doing that, Brett. But I do think the filings we're going to discuss today are very clear, and they are not written in a way that are meant to be confusing because they stick with the law. And of course, we are talking about the state of Indiana's response to the writ of mandamus in the Delphi murders case, as well as Judge Gull's own response.
Yeah, and so you guys are getting a two for this week. Yesterday we talked about the transcript of the hearing, and now we're talking more about sort of what's going on now with the mandamus and what's going to happen. Trying to answer some of the questions that you guys have had and just provide some clarity on how we think things are going to go. As we're going to tell you, it's always hard to predict how the high court is going to do anything, but we're going to do our best, and then, they will grade our papers. We'll find out exactly what we get wrong and what we got right, and hopefully a few weeks. Am I being too optimistic? A few weeks, maybe? I guess we'll see.
Let's dive in.
So at this point, Baldwin and Rosie go speak to Alan. Alan hasn't been present in this hearing. Sounds like from discussions later on that it's basically the policy of the Department of Corrections. They're not going to let someone who's accused of these sort of serious crimes in the chambers with the judge. Different places have different rules about that. I've certainly been in chambers with the judge. I think it just depends. It just depends on sort of what your rules are, what your safeguarding procedures are. So he's not in there. I don't like that. I wish he'd have been in there for the whole thing, but his lawyers are in there and they're about to go talk to him about it. So they go and speak to him. They come back and they basically say, look, this is all on very short notice, but Richard Allen wants us to stay his attorneys. And they're candid about the limits of Allen's ability to keep them on the case under the constraints of the law, which is something we have been talking about for weeks. But they say he wants us to continue with his representation. He understands, I think, that he's not the gatekeeper, or he doesn't have the authority to really force the court to do that. He would like to say that on the record. We have been telling you this for a couple weeks, that as appointed counsel, because he's indigent, he doesn't actually have the ability to keep them on the case. Rosie and Baldwin understood that at that moment. They obviously are now arguing something different because they want to change the law. They want to have new law in Indiana that would allow them to stay. But that is the rule. And whatever you want the law to be, that's what it is. And they understood that at the time. And they had advised their client correctly in the moment that not really up to him given the circumstances. So they want to put it on the record, but his counsel are concerned about having him speak on the record given that he is an accused murderer. I think this is interesting because I think this goes back to the fact they don't want to have this in open court. They don't actually want that to happen. And he's wanting to put this on the record, and they're like, oh, well, we wouldn't want him saying anything. Clients occasionally have to speak to judges on the record that have nothing to do with the crimes of which they are accused. So I found this to be a little disingenuous, but nevertheless, that's what they say. So Rosie says he's going to file a motion to withdraw, but he argues that he should have had more notice of what is coming. And this sets the stage for what you're going to see sort of in the mandamus petitions, which is essentially Rosie saying, if you were going to do this, you should have given us more notice. As we talked about, they had several weeks. I think what he's really saying is there should have been more formal notice. We should have known ahead of time in some sort of formal way that this was going to happen. I'll read, it's a rant. I mean, he goes on quite a rant. I'll read some of it to you. He says, I'm going to file a motion to withdraw. I don't want to do it, but I don't think that I have a choice at this point. The options I've been given without any notice by the court really are either I withdraw or I'm going to be publicly shamed, and that's the way I see this. And I think that public shaming is, there's not only a professional element to that, I think there's a personal aspect to that too. But when the media is teed up like this, and we show up here today with the court having told us that we were going to conduct some business, that somehow bleeds over into a forced resignation or whatever you want to, however you characterize this, I don't feel like that I have any other choice professionally. I have a life beyond the courtroom and beyond this case, and I have a family too, and I have a law practice. But I think had we been given some notice of what we were actually, if this would have been framed in a pleading format or some formal disciplinary claim, which there's a process for that in our business, then we could have come in here today with an opportunity to refute some of these things that you clearly had, thought through and prepared before we got here. And we didn't have the opportunity to do that. The idea that I'm going to have to go in there in open court and essentially defend myself against claims that I don't agree with without any notice, without any opportunity to think is unfair. But I have also some common sense. And, me going in there and standing my ground because my client wants me to is just going to make things worse for him. And so I'm going to withdraw my appearance. This is a moment of clarity for Rosie that he very quickly lost, that it's actually in his client's best interest to go ahead and get this over with. I'm going to walk out of here. I'm going to go down to my car. I'm going to call my staff and have them prepare a motion. I'm going to withdraw my appearance, but I'm doing it because I don't think I have any other choice professionally, not because I want to and not because my client wants me to. And I respect the court has an opinion, but we're professionals and we can disagree. The court says, of course. And, I'm extremely, I'd say frustrated, it's probably a soft word, with the idea that we showed up today without any real opportunity to prepare for any of this, like, I don't know, hiring an attorney and filing a memorandum on it. And I just think it's improper, and that's where I am, and that's my position. And this is he's staked out the position they're going to take going forward, which is we should have had more notice. This should have been more formal. Even though we don't actually want to have a formal hearing, we want to have some sort of hybrid private hearing where we can do this. And that's his position.
And I'm glad that the court kind of steps in here and notes that, kind of calls him on that lack of notice allegation that is just false. Because the court says, no, you were on notice, even if Rosie thinks it wasn't formal enough. So the court then goes on to say, well, I think we talked about when you asked for a disqualification, and I indicated on our phone conversation I'm inclined to do that. Mr. Rosie said it was a phone conversation that was not on the record, and then some follow-up emails. The court said, true. Mr. Rosie then said, there's an informality to that. The court responds again, true. Now, Rosie notes that the prosecution didn't formally move for their disqualification, and the court tells him that she's doing it on her own notice, which she's allowed to do. It's in the discretion of the court to do so. And Rosie kind of waxes poetic for a while about how he doesn't like that he's being given a choice between public shaming and being disqualified. It's not like the public shaming is not due to his own actions, right? This is my problem with his protestation. Is he's putting it yet again on anyone but himself, right? Oh, the court of the clerk accidentally filed the Frank's motion publicly. That's their fault. You're going to publicly shame me. That's why I have to do this. No. Everything in the public shaming, if that's how you're going to frame it, is a finding of fact by the judge based on your actions. So if you want to frame that as a public shaming, go for it. But it's not like she got up on the wrong side of the bed and decided today was the day she was going to give an attorney a tongue lashing, which, by the way, judges do all the time. I get publicly shamed all the time by judges, and not because of facts, because the judge just doesn't like the way I look that day and woke up really angry and didn't have a cup of coffee. They're allowed to do that. So it's a complete mischaracterization to call it a public shaming, especially when the prepared statement I thought was very fair. It was rooted in fact. It quoted from the transcripts of previous hearings and previous things said by Baldwin and Rosie. And it was not superfluous, flowery language filled with emotion. You heard her read it previously. But anyways, so Baldwin has been quiet through a lot of this, but for his part, he does thank the court for letting them have this meeting and saying that he, quote, appreciate giving us the advance notice. As he should, because this was going to be all done in open court for all to see forever and ever and could be career ending. So at least he has that moment of clarity and recognizes, thanks for doing this for us, Judge, because as terrible as this is, at least this was not in public. Until, of course, the defense causes all of this to be released, which is what we're now reading. So Baldwin doesn't give this soliloquy about every action he's going to take, from the number of steps he's going to take to his car to how he's going to call his office to file motions. He does something more straightforward. He just says he's moving to withdraw orally. And Baldwin asks for the court to wait till they get out to announce their withdrawal. And the court agrees to do that for them, again, to save them face.
And probably the person I felt the sorriest for was James Luttrell. I don't know if anybody who read the transcript noticed this, but you got James Luttrell, who at the very beginning of the thing is like this new lawyer who's come on. I think he might actually be an old lawyer who retired and joined the prosecution team, but it's his first time appearing on the case. He shows up at the beginning, and then at the end, the defense attorney's like, well, it was nice to meet you. And he's like, yeah, nice to meet you too. And I could just imagine what it was like for him to sit through this whole thing as it blows up on all the defense team. So anyways, I thought that was humorous. So that's the end of the transcript. So just some questions about this that people have asked us since this has been released and everything else. And one of them, the big one, is what is the Indiana Supreme Court going to do in this case? And the simple answer to that is, who knows? Who knows? This is, whenever things get in front of a Supreme Courts can do things that don't necessarily follow the law as you've seen it. That's one of the things Supreme Courts do. Now, in our episode from a few weeks ago, we laid out the United States Supreme Court jurisprudence on representation on the Sixth Amendment, and under it, Richard Allen loses. Just all there is to it. If you've read his mandamus petition, he barely mentions the Supreme Court, and there's a reason for that. And as we talked about, we cited this case, Kaplan versus Drysdale, a Supreme Court case, which makes it very clear petitioner does not, nor could it defensively do so, assert that impecunious defendants have a Sixth Amendment right to choose their counsel. Guarantees defendants in criminal cases the right to adequate representation, and that's it. And that's a big problem for him. So instead of relying on Supreme Court jurisprudence, he's relying on what I think you could term as the minority position, which is a position that a few states have taken, and they're allowed to have sort of a higher floor than the Supreme Court sets for what a defendant's rights are. And, they have their own constitutions, for instance. There's a California case that really underpins this. It's called Smith versus Superior Court of Los Angeles County. If you've read the mandamus petition, you've seen this case cited multiple times. This is a case from 1968. But here's what a 2018 California case says about that 1968 case. In a more recent decision, the defendant does not cite, however, you could almost imagine that being written about Richard Allen's mandamus petition, our high court ruled that to the extent that the holding in Smith and in 3 other decisions were based on the federal constitution, they have been superseded by the Supreme Court's decision in Wheat versus United States, which if you listen to our episode, we talked about a lot. Further, in Jones, the California Supreme Court squarely held that when a trial court removes a defense attorney because of a potential conflict of interest, the court is seeking to protect the defendant's right to competent counsel. In such circumstances, there is no violation of the right to counsel guaranteed by the state constitution. Thus, Smith is no longer good authority. So you have a California Supreme Court opinion that says that one of the key cases that Richard Allen is relying on in Indiana, in the hopes that the Indiana Supreme Court will adopt that position, is no longer good law. That's the kind of thing that makes it hard to succeed when you're arguing in Indiana courts. Now, if you want to, you can read what the state has said and what Judge Gohl has filed. There are 2 filings in this case. You may remember in the first mandamus case, the state, they said, we're not going to bother responding to this. The first mandamus really didn't have any issues to implicate the state. State didn't care whether or not certain documents in this case are public or not public. But once you start trying to expand the ability of defense counsel to stay on cases when they probably shouldn't, then the state's going to have an interest. So the state came in and they filed their own reply. I would like to think it sounds a lot like what we've said in the past, cites a lot of the same cases, cites Slappy, for instance, which is a great case, a great case name, and sort of lays out the same type of thing that we talked about. It makes a couple really, what I thought were great points. I mean, number one, it talks about how there's not much of a record here because there was no hearing, and it points out that the reason there's not a hearing is because the defense counsel declined to have one. It also points out that the Indiana Supreme Court has never ruled on this particular issue. Normally, that might be problematic. You like to be able to say, the Supreme Court has ruled on this and they ruled in our favor. But a mandamus petition, you have to show that what you're asking for is clearly something you should get. And when the Supreme Court's never addressed the question before, you can't show that. It's very well written. I thought the state of Indiana's response was great. Judge Gohl's is a little bit more directed at these 2 attorneys, I thought, and really kind of pointing out all the things they did. I thought the state of Indiana's response is probably going to be more effective in court. Judge Gohl's, I thought, was more of an effective, maybe defense of her, whereas, the state of Indiana doesn't care that much whether you think what Judge Gold did was proper or not.
Which makes sense, right? I mean, she's like being personally attacked and being dragged through the mud in these filings about her biasness and whatnot. So it makes sense where her position is coming from. So there's still a lot to talk about, because was there a due process violation here? On several occasions, the defense mentions due process. You heard it in the transcript from that meeting in chambers, and also, as they've done on multiple occasions, the former defense counsel keep talking about due process as if it is the lawyers rather than Richard Allen whose rights are at stake. Now, due process usually requires notice and an opportunity to be heard. But how much notice is required, and how formal does it need to be? The defense here had 2 weeks' notice that disqualification was on the table. That's why they wanted the in-chambers meeting, because this was about disqualification. Remember, again, Baldwin hired an attorney and filed a brief directed at why they should not be disqualified. So they certainly had notice of what was about to happen. So that's not an issue here. It's not about notice. Well, what about an opportunity to be heard? Because that's the second part of due process. The defense could have availed itself of that opportunity. A public hearing was scheduled, but they did not want that to happen. In fact, to the extent they wanted a hearing at all, they asked that it be ex parte, meaning without even the prosecution there, and in private. So even more private than the meeting that occurred. At no point do they ask for a continuance, which means to delay the hearing, so that they can prepare for a public hearing. That's very common, by the way. Oftentimes, if you have late found evidence or a newly raised argument, you can hear argument in court that whatever side wants to respond will say, well, Judge, that's a really good question you've raised, but we were planning to address points 1, 2, and 3 that you stated in your order setting this hearing. You're now raising point 4, and we just aren't prepared to discuss it at this time. We'd like to take the opportunity to fully brief that and have a continuance of this hearing to continue that discussion. That would be the proper thing to do. I've done that multiple times in court. When something kind of new arises and I'm like, you know what, I need to research that. I need to kind of really look into it and not just go off the cuff here. They had the right to do that, or at least to ask it. The court could always deny them the opportunity to have a continuance, but it wasn't even raised here. So there were proper procedures to be followed here that they didn't avail themselves to. Now, they also complain about the suddenness of everything that was happening, but they also say in that same breath that they have no interest in a public hearing that day or any other day. And the fact a public hearing would have been embarrassing or a public shaming, as they say in their words, is really not legally significant. They don't want a continuance of this hearing because they don't want any of this to be on the public record ever, whether it's today or later. And you don't have a right to not be embarrassed in court by a judge. Truly. If you did, like every lawyer in America would have a cause of action. I would have cause of actions left and right because I'm embarrassed by judges like on a daily basis. It's just like I wake up and I'm like, which judge is going to decide to embarrass me today? That is not a cause of action. That is literally just a rite of passage if you enter the bar. So you might be wondering, we've talked about lawyers. What about Richard Allen? Isn't he entitled to a hearing? Now, his lawyers appear to only be concerned about themselves and due process for themselves. So can they waive his right to a hearing? Now, this is a good question. And it's rare to have a situation like this because it seems like they can waive a hearing for him. In Merca versus Fairfield of America, Inc., which is a case out of the Indiana Court of Appeals from 1994, that court said, quote, in the absence of fraud by the attorney, the client is bound by the actions of his attorney, even though the attorney is guilty of gross negligence. What we have here is the judge making a finding of gross negligence against Rosie and Baldwin, yet Indiana's Court of Appeals opinion says that even with a finding of gross negligence, unless there's fraud by the attorney, doesn't matter. The attorney still represents the client, and the client is bound by what the attorney does.
So then you have the question, was the withdrawal technically sufficient? And this is sort of an underlying current in this sort of formalism versus realism that you kind of see going on here. So Rosie raises it in the hearing and talks about formal notice. Like, well, we had notice, but it wasn't formal notice, right? As if, all of this would have been solved just by the judge putting a notice out that said, on this day, we'll discuss whether or not the defense counsel should be disqualified. And then, because it was a formal notice that gave them the exact same information they already had, well, that would be good enough. But it's not good enough that you actually knew it. Generally speaking, formalism has fallen out of favor almost entirely. There used to be a time where courts were much more formalistic. And what I mean by that is the substance mattered less than the form. And the form really mattered. I mean, think about like a contract, right? Like you fill out the whole contract, there's a meeting of the minds, and there's a signature line, and you don't sign it on the signature line. You sign it on the bottom of the page instead of the top of the page. And 150 years ago, the courts might have been like, aha, you didn't sign it on the signature line. Therefore, contract is invalid. And now it's like, no. Was there a meeting of the minds or not? Did you have an agreement or not? If you did, we're going to treat it as binding and we're going to hold you to the contract. We're not going to let you out of it because of some technicality. It's the same thing here with sort of the formal versus the informal. Did they have notice or not? Did they know they were walking in there and disqualification was on the table or not? Did they know what the issues generally were or not? And that's really the question. And it's the same thing here with this technically sufficient withdrawal thing, which you see people raise. So people have pointed out that sort of the Indiana rules of professional conduct and the rules as to sort of court procedure may invalidate the withdrawal because they require 2 weeks notice and they require that the withdrawal be in writing. Now, the point of this rule is to protect a defendant from being abandoned by his attorney. You can't just decide to quit on your client. You got to give them some notice. You have to make it formal. That's not what's going on in this case. In this case, the court was prepared to remove both of them on their own motion. The court says that, like, I'm doing this on my own motion. This is just sort of allowing the defense to withdraw on their own to sort of avoid that embarrassment. So does that somehow invalidate what the court did? Well, assume it was procedurally flawed. Assume the court shouldn't have done that. Well, then you think about what's the remedy, because remedy matters too. And the remedy isn't always, well, I guess they just have to be back on. Well, all of that just goes out the window. Doesn't matter that they were negligent because the judge violated Rule 3.2 of the trial rules or whatever. No, the remedy would either be for the court to simply go ahead and remove them on its own, which essentially the court did that in this October 31st hearing where they'd show up again. Rosie and Baldwin show up again and sort of make some half-hearted effort to stay on the case. And the court explains, I'm not going to let you do this under any circumstances. So that would be one thing the court could do. Or any challenge to the removal that they now want to raise is actually invalidated as invited error. So you have a rule that says when the person challenging what happened invited the error, said, let's do it this way, judge. And the judge says, okay. And then they turn around exactly like happened in this case and say, ha, the judge messed it up. True, we told him to do it that way, but now we're going to challenge it. You can't do that. The law is not stupid, is something I like to say, and that would be stupid if you could do that. So I think it is highly unlikely that the Indiana Supreme Court, is going to find this to be a compelling argument. You never know with elected Supreme Courts, but I doubt it. I doubt that they're going to say, that means Rosie and Baldwin are now on the case for all eternity, and it doesn't matter what they did.
And especially with the invited error, that doctrine is very compelling, right? Because at root, what we're trying to say is we're just trying to get to justice here. We're not trying to do a gotcha. You signed on the wrong line, you used the wrong, font. That's not what's here. And if it weren't for this transcript being released, the invited error about what has happened would not be so clear. So again, the release of this transcript just makes it completely clear that this was all at the behest of the defense counsel, who are now complaining about the manner in which this was executed. It was at their request. All right, we're honing in, guys. Stay with us. We have one last topic because remember how there was also a pro bono filing. So we had told you in previous episodes that there are different rights for retained counsel versus appointed counsel. And in what we think was an attempt to somehow gain the protection of retained counsel, Rosie and Baldwin kind of turned around and offered to represent Allen pro bono. Now, will this succeed? Think about what it would take for this to succeed. First, the Indiana Supreme Court would have to endorse what is a naked attempt to circumvent the trial court's ruling. Second, the Supreme Court would have to do so even though Baldwin and Rosie have made no showing that they can afford to represent Allen competently without resources. It's not just their time, right? It's not just the billable hour or what have you. There are experts who cost tens of thousands of dollars, if not more. In a case like this, like a simple, easy peasy case, you can easily drop $30,000 to $50,000 on an expert to talk about a civil case on damages. For something like a criminal trial of a double homicide, and you're going to talk about maybe blood spatters to the bullet being discharged from the gun versus all these different experts you could have, we're talking hundreds of thousands of dollars of expert opinion and expert testifying opinion as well. They haven't shown that they can afford that themselves. And there were already rumors that the representation was putting a strain on both men's finances, and that's without doing it for free. Maybe they could afford a pro bono litigation, but they simply haven't shown that. And third, the Supreme Court would have had to find that the reasons given for removing Baldwin and Rosie weren't sufficient. Remember, this is not a case where the court arbitrarily removed appointed counsel just because she woke up on the wrong side of the bed. She clearly stated, as you can read in the transcript, that she removed them for cause, and she has the discretion under the law to do so. Even if the pro bono action has some effect, the question still resolves back to the merits. Does a trial court have the discretion to remove counsel for gross negligence? The answer is yes. And the best evidence that this pro bono filing has no real legal significance doesn't come from what we're saying. It doesn't come from what the judge says in her filing. It doesn't come from the state of Indiana's filing in response to the writ of mandamus. It comes from Allen's own mandamus petition, because the defense doesn't even bother to make this argument about pro bono.
And that tells you all you need to know.
Yeah, silence is deafening.
Yeah. If the new lawyers who did the mandamus thought that had any chance to succeed, they would have made that argument. They didn't. So, yeah. I mean, people bring that up, but yeah, I mean, there's no answer to it. Like, I can't point to a case for you on that because I've never seen anything like this. I mean, the idea that you would be removed by a judge in these circumstances and not just leave, it's hard to imagine. But that's where we are. And that was long and that was a lot, but I think that covers just about everything. I'm hoping that we're done with Delphi for a while. Presumably,
I'm hoping we've poured cold water, at least, on these filings and the transcript, that there's nothing to see here. Like, there just isn't. And for the sake of Richard Allen, Baldwin, I think, was it Rosie, who said in the transcript, "Can I stay on for judicial economy?" This is the opposite of judicial economy. This is wasting the court's resources, and I don't just mean Judge Gull. I'm talking about the state of Indiana, and I'm talking about the Supreme Court, and it is wasting time for Richard Allen as well. He is not better off because of this sideshow circus. So it's time that they step back and kind of accept what the law requires here.
And just as a matter of, these lawyers have proven that whatever they are not the only people in Indiana who can represent Richard Allen. This is not a case where Richard Allen is not going to get a vigorous, competent defense unless it's these two guys. And this is just, as Baldwin said, this doesn't have anything to do with Richard Allen anymore. This is all about them. He didn't mean it that way, but that was a moment of truth. And I just really hope the Supreme Court of Indiana just squashes this. I hope they do it in like a 3-sentence opinion and we move on. I mean, it's interesting because the state of Indiana, the Attorney General's filing kind of points this out, that Rosie and Baldwin complain about the lack of a hearing. But once again, even in the mandamus petition, they're not really asking for it. Like, that's sort of the only thing I could imagine the Supreme Court doing, is sending it back for a hearing, but they don't even really ask for it. So I think, number one, I can't imagine a circumstance in which the Supreme Court just reversed Gull and put them back on the court without some sort of hearing, or back on the case without some sort of hearing. I just can't imagine that. That doesn't even make sense, because then I think she could probably order a hearing, unless the Supreme Court made a very strange ruling in which it was like, you can never remove them. Like, they're back on the case and you can never remove them. I don't think they're going to do that. So if they come back, best case, I think there's some sort of evidentiary hearing. As I said, I think when we talked to Murder Sheet, I think what they're hoping is they'll also remove her from the case, send it back for an evidentiary hearing that a new judge just doesn't even bother to do. And that is, I mean, maybe they'll shoot that gap, but we'll have to see.
I've used all my words I can, at least for this week on Delphi. We're done.
We're done.
I hope so. I hope so, at least. Well, I mean, I really hope that this is clarified, or like we said from the very beginning, you guys don't need us. You can read these filings yourself. We've, tried to stick with straight what the transcript says, what the filings say, and not, kind of shade them for you. But of course, it's our point of view. So go read these filings for yourself, and we'd love to hear from you. If you have any additional questions, please write to us at prosecutorspod@gmail.com. Reach out to us on social media. We're on X, formerly known as Twitter, Instagram, Facebook. We have a fan-run Facebook group, The Gallery, where a lot of awesome discussions happen, including about the Delphi case. So with that, Brett, is there anything you'd like to add before we sign off for the day?
I've said enough, Alice. I'm done.
Wonderful. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. That's not a word, but what if I made it one?
You do whatever, Alex.
Okay. I'm ready.
All words started off as not words at some point.
That's one way to say it. Okay. We're going to cover it all today, right?
We're going to try.
All right. Yeah.
Okay, so Jason, that'll be the outro for the first episode. Now we're going to do the intro for the second episode, and you can use the outro we recorded before as the outro to the second episode. So there you go.
Master puzzle piece maker. Mm-hmm. Okay.